I call the member for Holt.
Thank you, Deputy Speaker, and it's my pleasure as Deputy Chair to speak on the advisory report on the Telecommunications Interception and Access Amendment Data Retention Bill 2014, and appreciate the opportunity to relatively briefly speak on this particular report. I would also start off, Deputy Speaker, by commending all of the members of the Parliamentary Joint Committee on Intelligence and Security. Deputy Speaker, it's not a committee where you get headlines or you don't get the latest instalment of some breakdown in bipartisanship where one person says one thing or another person says another thing. It's one of the very few committees in this Parliament that comes together and puts aside political considerations in the national interest to come up with the best possible consideration of any legislation or matter before it. And I think in this matter, given the competing tensions that existed in the matter that was being debated and the depth of feeling within the community, matched by the desire of the agencies to have the powers that they are seeking, that it says much for the debate that occurred within the committee. It says much about the quality of the character of the committee members and the way in which this matter was dealt with. And I would like to commend the chair of the committee, the member for Wannon, for his incredible work in very difficult circumstances, and I know Mr Nikolic is there, and I commend him for his work on the committee as well. And also to the long-suffering Secretariat who are sitting in the advisory box as well. Thank you for your enormous work, and the two secondees that we're not allowed to talk about, but we'll say anyway, thank you for all of your work. There is, unfortunately, when you read the headlines and the cutaways, Deputy Speaker, you don't see just the phenomenal amount of work and consideration that goes into a matter as complex as the one that we're debating here today. As the Chair said, Deputy Speaker, in 2012-2013, the committee or its predecessor was faced with an enormous task of reporting on an extensive collection of proposed national security legislation reforms. We've seen the follow-through with that, with three tranches of legislation that have come before this Parliament, and this is the third tranche of legislation that was contemplated in that 2012-2013 report. And I'm certainly pleased that a number of the reforms proposed have been considered and referred to the committee for further consideration. And it is with great pleasure that I'm able to talk about the advisory report on this third and probably most controversial tranche of national security legislation reform. Look, leading up to the inquiry, Deputy Speaker, there was little doubt that data retention would be the most extensive and controversial tranche of the proposed national security legislation reforms. But it's also important to state that these reforms would be probably amongst the most significant tranche in ensuring the protection of Australia against the ever-growing threat posed by terrorism, both international and homegrown. Now, despite the threat level we face today, the proposed changes to the Telecommunications Act certainly haven't been welcomed by open arms by all parties concerned. We acknowledge that. But it's been the role of this committee, this unique committee, to take into consideration the position, knowledge and insight of all the parties both for and against these reforms. The committee was then required to assess whether the proposed changes were necessary measures to take, whether the measures proposed were a proportionate response to the threat that we face today, and whether granting these measures is an appropriate response to this threat. And the decision taken by that committee was that these powers needed to be given to the agencies to combat the ongoing threat of terrorism in our country. And as someone who has had a terrorism event occur in his electorate, I can speak with some measure of authority and of knowledge about the impact that a terrorism event does have on your community. This is not mere discussion for me about a proposed or potential terrorism threat. This is a real event that occurred that led to the almost murder of two police officers and the assailant basically being killed by an officer trying to protect himself, his fellow officer and the Endeavour Hills Police Station. So whilst I counsel some about this discussion in the national discourse about terrorism being a long way away, for me it wasn't a long way away. For me it was real. It was real enough to be that it was some 300 metres away from where I used to live for many, many years. This is not a hypothetical event for me. This is an event that occurred, and that informed a lot of my consideration about why the agencies did in fact need these powers to combat the threat of terrorism. And one of the key things that came out in the evidence in terms of why these agencies need these powers, that some describe as draconian, but I would describe as necessary, is the incredible pace of change that is occurring, the radicalisation, in some cases, Deputy Speaker, up to 4 weeks, when someone accesses the internet and becomes radicalised. And I've seen this in a local instance, not far away from my electorate, where a young woman has been radicalised in the period of 4 weeks and is now one of the so-called jihadi brides in Syria. So this is not a theory for me. It's not a theoretical discourse about what might happen in our country. It's what has happened in my electorate, what continues to happen around my region, and what we need to do to give the agencies the powers to prevent further activities of this nature taking place in my electorate, in my community, in our country. And it's not as though this committee had not considered these matters carefully and deeply. As the chair will know, we took hearings, we took evidence from a variety of individuals, both from the agencies that were seeking to have the powers, but also those that were diametrically opposed to the agencies and the law enforcement agencies having these powers. And I must say, Deputy Speaker, in contemplating the outcome of these reports and these hard-argued recommendations that come before this Parliament, that I hope will be adopted in full by the Attorney-General, that we will see reflected in the legislation before the House, I think, or the Senate before the end of this week, I think, that is a sort of testament to the work that's been done in a bipartisan way with the committee. And for those that say that this has been rubber-stamped by the committee, which I find offensive, I would say this: look at the 38 recommendations that are contained within the committee. I've been somewhat disheartened, I must say, Deputy Speaker, by some of the commentary about the fact that this committee basically didn't look at the matter seriously, that it didn't offer the community the protections that it needed. And I'd ask those that make those criticisms to examine the regime in the United Kingdom and the United States. In my view, Deputy Speaker, having been chair of the previous committee and deputy chair of this committee, there is no other committee, to my knowledge, in the Western world that has looked at data retention as closely as our committee has, that has had that much input into the structure and the architecture of this report. And I might also say, Deputy Speaker, with respect to those that you would have expected to have criticised this data retention regime, that we've had eminent people like Professor George Williams from the Gilbert and Tobin Legal Centre that have accepted the need for a mandatory data retention, and also, I think, Professor Gillian Triggs, who, the Human Rights Commission, acknowledged that there was a need for a data retention regime. So I would say to those that blithely say that the committee hasn't fully considered this matter, that it has, that there have been many, as the Chair said, many hours of discussions about the principles that surround the architecture of this metadata regime. And then just quickly finishing off, you look at some of the protections, listing the data set in the bill itself so we know what data is being retained, limiting access to telecommunications data to only those law enforcement agencies specifically listed in the bill, oversight of operational use of this legislation by the committee, which is the first time this committee has been given the power, authorising ASIC and the ACCC to access telecommunications data to assist in the investigation and prosecution of white-collar crime, requiring telecommunication companies to provide customers access to their own telecommunications data upon request, requiring stored data to be encrypted to protect the security and integrity of personal information, prohibiting access to the telecommunications data for the purposes of civil proceedings, for example, preventing its use in copyright enforcement, requiring a mandatory data breach notification scheme to ensure telecommunication customers notify consumers if security of their telecommunications data is breached, increasing the resources of the Ombudsman to strengthen oversight of the mandatory data retention scheme, a mandatory review of the data retention scheme by no later than 4 years from the commencement of the bill. Deputy Speaker, that is a very comprehensive list of safeguards, and they're not the safeguards in its entirety. Deputy Speaker, we cannot have a discussion about national security laws without acknowledging the growing threat that our country faces from the terrorist measures, the terrorist menace. And what I think needs to be contemplated by those that have some resistance to this metadata regime is that it can be reassured that the committee looked very extensively at the case for and against. You can be rest assured that some of the safeguards that have been put into this report that hopefully will be enshrined in legislation are amongst the strongest safeguards in the Western world for any data retention regime, and you can be reassured that we will continue to monitor the implementation of this data retention regime. Deputy Speaker, it has been a great honour to work as the Deputy Chair on this committee on this report, to work with my fellow committee members, and I certainly and wholeheartedly commend this report to the House.